Hi, I'm Jonathan.
Hi, I'm Ian. I'm good.
And I'm Jonathan, and I'm the reply.
Thank you. We will now have opposition to introduce themselves and do their technical check.
Hello, everyone. First opposition speaker, Timothy.
Everyone, I'm Kausar Khanna, I'll be second opposition speaker and reply.
And I'm Michelle, and I'll be third opposition speaker.
Thank you. Observers, coaches, and team managers are reminded to keep their microphones and videos off at all times during this debate round. Judges, may I confirm that you are ready for the match to begin? We will now have the first speaker from the proposition to begin the debate.
Hi, am I audible?
Yes.
In the same courtroom, on the same day, and by the same judge, Chase Laitliner was sentenced to 2 years in county jail and Lamar Lloyd to 26 years in federal prison for the exact same crime of armed robbery. The only difference between these two men, their race. This reveals the fundamental arbitrariness of human judgment and the inherent biases in sentencing trials where judges, in status quo, are allowed free rein to decide within the wide spectrum of maximum and minimum sentencing for a crime. We solve this with our policy. What is government's mechanism? 3 prongs. 1, we would completely remove human judges in sentencing trials and rely upon algorithms as the sole determinant in sentencing. 2, the mandate to construct this algorithm will be created by an independent body without political interference, and it consists of criminal justice technocrats who have the most knowledge on the systemic biases and flaws of the system. This will be a transparent process in which the algorithm can continuously be improved to improve its level of efficacy. Thirdly, what will this algorithm look like? And we're just going to do a bit of characterization here. It will be programmed to evaluate both the type of punishment and the duration of sentencing, with the goal of prioritizing rehabilitation, the risk of reoffending, and the severity of the crime over other metrics such as retribution. We would use a host of punishments that aren't necessarily jail time. So rehabilitation, community service, fines, etc. We would take into account non-exhaustive metrics such as individuals' past history of crime, remorse and ease of rehabilitation, severity of the crime, personal upbringing, etc., and compute this objectively. For an illustration, if you're low income and you committed a crime of necessity in order to survive, your economic desperation can be used as a mitigating factor, and we would recommend specific punishments like job training that would reduce of recidivism. But before I go into my argumentation, let's first clarify in what ways are sentencing trials uniquely different from conviction trials and why must we focus on them? For 2 main reasons. Firstly, the law provides an extremely wide scale of minimum and maximum sentencing for a single crime, granting judges the power to excessively over and under penalize criminals based on arbitrary considerations like their race and their own personal worldviews. As a direct result, two criminals who committed the identical crimes may be punished very differently under side of opposition. But secondly, sentencing trials are far easier to compute via algorithms as opposed to conviction trials where there can be an infinite number of circumstances and complex evidence. Sentencing trials follow a set of metrics that can easily be calculated by an algorithm to obtain an objective and equitable decision. I have 2 argumentations in my speech, but before I continue, are there any points of clarification?
Yeah, okay, so I want to go back where you say that the human judgment system has biasness, right? But then you also say that the data that's going to be provided for these algorithms will be based on the people who have enough knowledge. So basically, you're just going to take opinions from the rest of the people who have knowledge. How do you clarify this biasness?
So my first argumentation will about why judges are inherently biased. But our model gave 2 reasons why technocrats would be the one doing this. But you assume that we will over-penalize individuals. That's not true, because we're doing a rehabilitative algorithm. Under your side of the house is racist, because the specifically tailored to firstly rectify this racism, but rehabilitate individuals under our side of the house. We told you to use things like poverty as a mitigating factor. The comparative that you have to defend is racist punishments that are already status quo. 2 argumentations. Firstly, that computer algorithms uniquely uphold equitable and impartial sentencing, rectifying a broken justice system. I have 3 reasons why human judgment undermines fair sentencing. Firstly, that every judge has a unique upbringing and a specific worldview on the application of law. This is to say that different judges view circumstances differently, and no amount of training or jurisprudence studies can change their inherent worldview. Some judges are excessively lenient or harsh as they prioritize different goals within the justice system, like retribution over rehabilitation, or the fact that they had zero tolerance towards some crimes due to their personal experiences with crime and the justice system. Additionally, your political and moral compass can affect the way you adjudicate criminal behavior, because right-leaning judges tend to over-penalize because they are tough on crime, while left-leaning judges under-penalize. Both of these are inequitable. Second level, judges are vulnerable to changing human emotions that determine the fairness of judgments. Judges are humans, note panel, that they are vulnerable to emotional stresses that affect their cognitive abilities and their rationality. So inside court proceedings, overly emotional victims have the ability to sway judges towards over-penalizing the perpetrator, whereas overly emotional perpetrators will compel the judge to under-sentence. Outside of the courtroom, externalities in their lives may impact their emotional stability at any given moment. We're talking about turbulent relationships, life-changing circumstances that would sway even the most mentally resilient of individuals. The third reason as to why human judgment undermines fair sentencing is that judges are often swayed by the abilities of their structurally disadvantaged. In sentencing trials, highly experienced and more expensive lawyers can persuade judges to prioritize metrics that advantage the client, while underpaid public defenders have no such incentive or experience to fight for the freedom of their clients. This results in an unequal application of sentencing laws depending on the wealth of criminals. Our algorithm computes defined metrics and evidence in an objective way as mapped out by technocrats, and the weighing of metrics is applied equally in all cases. What are the harms of this? So firstly, we would note that the most fundamental maxims of the justice system are equality before the law and impartiality, which they must undermine under their side of the house. But there are 2 more tangible and dangerous harms as well. Firstly, that over-penalization results in the complete loss of trust in our justice system. The legitimacy of judgments is called into question, and individuals believe that the criminal justice system is persecuting them instead. This undermines our ability to gain societal cooperation. So for example, how African Americans are unwilling to offer information to law enforcement agencies that can help prosecute crimes because they believe that the court system is intrinsically against them. But furthermore, on the other hand, under-penalization emboldens crime culture. As privileged members of society, believe that their race and their wealth and other factors entitles them to the leniency of the law. Hence why wealthy white celebrities and politicians are the primary perpetrators of rape culture, leaving behind a string of silenced victims. This asymmetry between perpetrator and victim further leads to underreporting and under-prosecution under their side of the house. Into my second argument about why human judgment is skewed by personal biases that disadvantage the most vulnerable. Firstly, racism is ubiquitous in criminal sentencing. In the Northern Territory of Australia, 86% of the prison population is Indigenous, despite this group only making up 3% of the population. This means that this points to the fact that the average judge is human and susceptible to prevalent stereotypes and bigotry that designate vulnerable minorities as aggressive, more immoral, and more dangerous, leading to the over-sentencing of these groups. These biases are extremely difficult to alter, and they're perpetuated by holes in the justice system for 4 main reasons. Firstly, judges can act with impunity because the independence of judiciary renders it a near impossible task to remove them from office. Secondly, they have the legal knowledge and expertise to rationalize any legal decision using any available legal metrics. Therefore, racism is hard to detect and easily explained away. Thirdly, appeal processes have high barrier to entry because you have to prove a gross miscarriage of justice. It is also extremely expensive and therefore highly inaccessible to low and middle income groups. At the very best, these appeals are reactive and uncertain when harms have already been incurred to the vulnerable. But finally, the fourth level, that training also does little to undo the kind of biases that have been ingrained in your mind for decades since childhood. It is almost impossible to be cognizant of your subconscious bias that you don't know even exists in the first place. This means that a judge may never realize that their racist tendencies decided that this black man was less remorseful and more dangerous than his white counterpart due to his implicit biases. The consequence of this is that unfair sentencing cripples a person for life, further disenfranchising vulnerable communities. Even if the average judge isn't blatantly racist, which is the best case scenario, our side gets systemic change whilst they rely upon the luck and goodwill of judges for minorities to escape the shackles of mass incarceration that they've been suffering under for far too long. Side with problem.
The speaker spoke for 8 minutes.
We will now have the first speaker from the opposition to begin the debate.
Can you hear me? Okay. Ladies and gentlemen, criminal law theorists believe that sentences are only able to serve two purposes. Number one, these are the goal of deterring future crime by both the convicts and by other individuals contemplating a committal of the same crime. Number two, a sentence is only able to serve the goal of retribution, which poses that the criminal deserves a punishment for having acted criminally. Now, when sentencing, a judge must impose the least severe sentence that still is able to achieve both goals, while also considering the need for societal protection. They tell us that we should remove human judgment completely, but we come and give you two solutions, ladies and gentlemen. Number one, we think that we can create more accountability. This in the sense that we can add more judges to the judiciary system. When we have more judges from different backgrounds, ladies and gentlemen, we're able to get more diverse decisions from various people, and therefore we do not need to eradicate this human judgment. Number two, we tell you that the second solution is that before a judge gives his decision, he or she can seek assistance from other peers, and by that we can have also the first decision for the sentencing. Now, the rest of my rebuttals will come in my speech. Today, I want to talk about the principles of criminal justice. And number one, we have social contract. Ladies and gentlemen, with social contract, we understand that people, all citizens, have given their rights to government, right? They have traded it off for protection and security and other things. Now, citizens have handed over their responsibility to the state and not to these algorithms that we're talking about. Then the question is, why do we give this responsibility, or why do we hand this power down to these algorithms? Now, we also tell you, panel, about the issue of efficiency. We think that despite these algorithms being efficient, we on our side have more accountability. Now, ask yourselves this question. Why does society have trust and confidence in human judgment? This is because we tend, as human judges, we tend to have more accountability than these algorithms that we're talking about. This is why states sacrifice efficiency for accountability. Therefore, we can trade off efficiency for accountability because that becomes unjustified. And this is why it brings me to my second issue, which is retribution. Now, ladies and gentlemen, retributive justice responds to criminal behavior that focuses on the punishment of lawbreakers and the compensation of victims. In general, the severity of the punishment is proportionate to the seriousness of the crime. Now, we also ask ourselves this question: who is the best actor for this retribution? And we think as an opposition that we have human judges who are the best actors, and we're here to give you 4 reasons as to why we think that. Number one, a human judge is one who is able to understand and can gauge from a human view or from a human perspective. Now, ladies and gentlemen, computer-based algorithms may not be able to understand the emotional causes for these crimes that are being committed. As much as I know, these computers are not able to read the emotional status of a human being. It is something that only lies with these human judges. Therefore, we feel that empathy and feelings are some things that only lie with human beings. Number two, context. The circumstances that form the setting for an event, statement, or idea, and in terms of which it can be fully understood. Now, what do I mean by this? A judge might know the circumstance under which a certain crime was committed, and by that, they're able to judge from that specific issue. Algorithms do not have context, ladies and gentlemen. They're not able to fully understand what might be going on. But with human judges, they have context and they're able to fully understand the issue that is being held on, ladies and gentlemen. And this brings me to my third issue, which is accountability. Now, by this, we talk about responsibility. We tell you, panel, that with human judgment, we are able to hold these judges are accountable. I believe there's no way we can hold these machines accountable for this criminal sentencing. We need to realize that these machines are not perfect. We cannot completely hold them accountable, but with human judges, we're able to hold them accountable. That is why we feel that we cannot eradicate these human judges. Number 4, we talk about transparency. As opposition, we do not know what these algorithms relied on to make their decision. We don't think they're really transparent. Even if they were right, we don't know the factors or where it relied on. This is why we think that human judgment is more transparent compared to these algorithms. Now, ladies and gentlemen, what are some of these outcomes of algorithms? Number 1, we talk about cost effectiveness. We think that these algorithms can be cost effective. Let's talk about something like capital. Capital in terms of 3 things. Number 1, data collection, data analysis, the systems being made and maintained. Now, these 3 processes all use money. They are cost effective in terms of capital, ladies and gentlemen. Let us also think about cost in relation to these companies that are actually, making this. One thing we know is that they're not really government based. It is a lot to do with the private sector, ladies and gentlemen. Look at something like the Compass risk assessment tool. It was not government based, but rather it was made by a private company. Therefore, even with computer algorithms, cost effectiveness is a factor not only just for humans, but also for these systems. We also tell you about time. Now, panel, we think that for a case to be hard and for it to be given the best solution, time then is a factor at hand that needs to be catered for. Therefore, a judge needs time to come up with proper decisions for the judgment. We tell you that isn't it better for us to take time in investigating a case rather than rushing to free a computer with information that maybe is not even investigated, ladies and gentlemen? Let me give you an example of a lady who was arrested because of murder. She was arrested because she had killed a man. And when the case was investigated, they came to realize that this man had been sexually harassing this woman, raping her and abusing the woman. So at one point, this woman got pressurized and, she decided to just kill him. Ladies and gentlemen, what is the analysis behind this judgment? That with human judgment, there is a lot of flexibility. Algorithms do not think like human beings. They are set in a specific way that it will just react to the action that it has been given. In that same case of the lady, this computer, just reacted to the case that it was murder. But when the case was investigated and time was taken, there was a different judgment to this scenario. Now, ladies and gentlemen, time is very important in criminal sentencing. And the fact that we think that we can save on time because of a machine, then that's absolutely wrong. We also talked to you about biasness and corruption. Now, maybe one of the benefits includes how algorithms will undercut biasness, discrimination, and mental shortcuts inherent to human judgment. However, 2 arguments. We tell you that algorithms not perfect in any regard. This is primarily because any algorithm needs to be coded by a human. This can introduce what we call unintended bias from the onset and biasness nonetheless. Now, what is the analysis towards this argument? I tell you that small irregularities and biases can produce a measurable risk in the final sentencing. For instance, there is evidence that despite similar rates of drug use, Black Americans are arrested 4 times the rate of white Americans on drug-related charges. Therefore, even if an engineer were to come and faithfully collect data and create an algorithm, it would still pick up embedded biasness. Secondly, I tell you the idea of junk in, junk out. A major use of algorithm is to identify correlation within data set. However, ladies and gentlemen, a major use of algorithm is to identify correlation within the data set. However, depending on the type of data, this could lead to a false positive and is not useful for identifying the underlying causes. For example, let's talk about poverty. Poverty is not necessarily a direct cause of criminal behavior, but it can be an indirect cause where it will create conditions that make crime more likely if errors are made on correlations. The final decision will quickly generate either a higher sentence or a lower one. So, ladies and gentlemen, we tell you today that we find that there's no need of eradicating this human judgment, but we tell you that, number 1, we can create more accountability in the sense that we can include more judges to the judiciary system. Number 2, we can have these judges seek guidance from other peers so that we can get diverse decisions from these judges. So therefore, we tell you that we do not feel like we should remove this human judgment because we feel like there's also biasness in these computer algorithms, and there are also other factors that are even more as in human judgment. Therefore, we feel that, ladies and gentlemen, we should not remove this human judgment. I rest my case. Thank you.
The speaker spoke for 8 minutes and 9 seconds.
Judges, are you all ready to listen to the next speaker? We will now have the second speaker from the proposition to begin the debate.
Hi, can you hear me? Yeah. All right, great. Panel, it is important to note that racism is literally entrenched within our criminal justice system in the status quo. That Ejan told you that 86% of the prison population in Northern Australia are Aboriginals when they only make up 3% of the Australian population. That the Department of Justice shows that black men are twice as likely to be sentenced to death for capital crimes in comparison to white males. We stand with Tanya McDowell, Aaron Bailey, Lamar Lloyd, and Brian Bax, all of which were disproportionately punished as compared to their white counterparts. I think it is abhorrent for Team Kenya to say, look guys, racism exists. Our solution is to add more judges. How on earth do they rectify the systemic failures and inherent biases that Ejan sophisticatedly analyze for you in this case? So firstly, I'll look into their model and tell you why exactly it is insufficient to the system. The first is that said, we can use more judges and therefore have more check and balance. The second is that we can seek assistance from peers. I'll first like to point out that in the status quo, this already exists. That is to say that they already have a panel of individuals whereby they can consult. They already have peer review within their system of judges and they have consultative measures. Here is the problem. The innate biases and the innate structural subconscious racism that exists is what prevents them from doing so. So they cannot just say that more individuals would thereby lead to more accountability because they in fact exacerbate the human flaw within the criminal justice system and exacerbate the amount of racism and inherent biases that exist. We don't think they even responded to what Ejan told you about the fallibility of human minds and how literally even like them, slipping down or going to a football match and seeing their team lose could be little things like that could influence their mental calculus. Now, I want to clarify one thing. Because they said that we would be basing it off racist statistics, that would mean we also overpunish individuals. The reason why technocrats are categorically not swayed by racist tendencies is the following two reasons. Firstly, Ejan told you in our mechanism that the job of technocrats is to solve the structural flaws of the criminal justice system, which is high rates of recidivism. So, what this means is that the algorithm will be recommending a rehabilitative model because a rehabilitative model has been proven in areas such as Norway to be the solution to lowering recidivist rates. What that means is that even though the statistics upon which we look at may be racist and discriminatory, we are using that statistics and the literal purpose of our algorithm is to solve and rectify for the racism, which is why we get the counter model to that intrinsic biases in the system. But I would just like to point out that in the status quo, judges are the ones who overwhelmingly put punitive measures rather than rehabilitative measures. Recognize, panel, that a current recognized aggravating factor within the criminal justice system is anger from the public. That just because the public is more angry, that means that you get a disproportionate punishment upon your perpetrator, which then leads to higher rates of recidivism and more spillover harms and social ills to society. That's a world in which they have to defend. We told you that we have a sufficient mechanism to counteracting that. What did they then say? look, guys, it's not just for you to use time and efficiency as a reason to implement this algorithm. We never said time was a reason. Efficiency never was our argument. We only told you that we wanted to rectify racism in the status quo. They then said, look, how is your algorithm going to take into consideration for emotions, empathy? How is it going to factor for context? We told you that the framework is to create an objective mechanism based on facts and data and apply it impartially. What this means is that we can utilize things like clinical psychologists who can determine the level of trauma. We can use psychiatrists to then give us the data and therefore input this into our algorithm upon objective metrics to determine what the punishment and sentencing should be. But just notice that this debate still needs to operate on a comparative, and it was insufficient of them to simply say, hey, your algorithm isn't good, when they literally do not want to recognize that individuals and judges are fallible and inherently biased, and the leanings of the judges are one that literally leads to someone like Brock Turner being sentenced for literally 6 months for raping a woman. That's the world that they have to stand for. The last thing is that they talked about is about accountability and this ability for us to check and balance. I would just firstly like to note that on a comparative, judges are literally not held accountable under their side of the world, where they literally have things like tenure that means that they can justify all these sorts of racist leanings that we have. We think that we are held accountable because each technocrat has an incentive to do so in order to ensure that they meet the objectives that we set for them. That is to say that Parliament can also look into things like how effective is it and thereby have a rectifying and accountability mechanism to ensuring that they do their job properly. The conclusion to all of this is that even if they say that an algorithm may not be able to determine or be objective and 100% in every instance, we need to recognize that this debate still operates on a comparative look in the status quo and the racism which is entrenched. Into my exclusive argumentation, which is that computer algorithms are the best method for criminal justice reform for effective rehabilitation of criminals. But before I continue, are there any POIs? No. All right. Now, why is this the case? 3 reasons. Firstly, human sentencing results in extremely high rates of recidivism. Look, in the United States, recidivist rates is at 60% because judges are often extremely punitive and do not prioritize rehabilitation. The reason why this is the case is that society's perception of deterrence is punitive sentencing and jail time. That's why judges often reflect this and do not maximize the tools at their disposal. Community training, job training. Therefore, on opposition, their best case scenario would be some mediocre rehabilitative measures in jail, whereas on proposition, our algorithm would prioritize having no jail time at all if serving jail time is proven to be counterproductive to rates of recidivism and rates of reoffending. As this computer will continuously use the rate of reoffending as its barometer of effectiveness, technocrats will recalibrate its algorithm until the flaws of the CJS have been corrected. But the second thing to note is that over-penalization of crimes for criminals who do not deserve it become counterproductive to rehabilitative goals. Putting non-violent offenders in prison for prolonged periods, giving poor people fines. This situation that has literally forced them to resort to prolonged periods of committing recidivist crimes, trying black juveniles as adults. Prisons are essentially criminal factories with inhumane living conditions that cripple the ability of offenders to function in society upon release and force prisoners into lives of violence and gang membership in order to survive. This, on a net, then creates more prisoners and more individuals who commit crime, and it then means that we have a more dangerous society that would not have existed if appropriate punishments were given as opposed to the status quo. But the last thing to note is that rehabilitation as a primary goal of sentencing best fulfill all the tenets of justice, right? Because if this rate of reoffending is high, it results in the total and abject failure of the justice system as deterrence has failed to prevent them from committing more crimes. Retribution fails as more and more victims are created in society through repeat offenses, social safety is manifestly compromised, and these individuals are unable to reintegrate back into society. By prioritizing the effectiveness of rehabilitation, we are safeguarding the rights of future victims and fulfilling the fundamental goal of the justice system, which is keeping society safe. Note importantly that opposition cannot co-opt effective rehabilitation because judges are humans that play into the same hand as retribution and also do not have the oversight to predict when jail time is the best punishment to be. At the end of the day, panel, Do not rely on the goodwill and luck of team opposition when an algorithm can structurally reform and curb and root out the structural racism that exists on the outside of the house. We do not stand for mass incarceration. Go to side proposition.
The speaker spoke for 8 minutes and 37 seconds.
Okay, can you guys hear me? All right, I'm gonna start. The criminal justice system clearly has its flaws, but the answer, however, does not lie in the replacement of the human judgment for algorithmic sentencing. We on opposition believe that replacement does not equal improvement, but the improvement on our current problem. And in this context, the human judgment is going to equal better changes. Now, as second speaker of the non-affirmative delegation, I'll begin by rebutting key issues brought in by the opposition side of the House, but secondly, panel, I'll move into our positive matter in the debate, where my 3 points of extension will include equitable justice versus the codified justice, secondly on the issue of necessity, but thirdly on the issue of alienation. Now, key things to note from government side of the House. They focus their first and second speech mainly on the issue of biasness. And they come and give us their claim that human judgment is fallible. They keep on talking about human judgment and defending the status quo. Now, our response to this is basically that we gave you a counter solution where we talked about having a more diverse judgment, right? Where we're going to include a review system, where we're going to have more judges on the panel. You know, it's not going to be necessarily only the white people or only the black people, right? We gave you a counter solution, but they came in that they still poked on biasness. Now, we have to remember that they come and say that technocrats are not going to be swayed by biases. But ladies and gentlemen, it's important to remember that this data that you are going to be encoding and using for the algorithm is, as they said, inherently biased. So ladies and gentlemen, by bringing algorithmic sentencing, you're not going to solve the problem of biasness. Rather, we feel that you're going to actually increase, because you're going to tend to sentence criminals and give a higher offense rate for the criminals based on this bias data. Secondly, they come on the issue of rehabilitation of criminals. Now, on our side, we also incentivize the rehabilitation-focused sentencing. We don't need algorithms to come and start incentivizing rehabilitation. Why do we say this? Look at the examples of Norway, Sweden. These are countries that have rehabilitation-focused sentencing, right? And they have the best rates. But what happens is, panel, they don't use algorithmic sentencing, so we don't see the justification of algorithmic sentencing coming into and start incentivizing rehabilitation. Now, onto my first one, equitable justice versus very comparative analysis, right? On our side of the House, I'm going to show why we, using human judgment, have more equitable justice. Because on our side of the House, we believe that our equitable justice by human judgment will entail both the reflection on the values set in place by the legal system and the recent application of those values in the context, right? It aspires to apply the consistent principle and is prepared to set aside general patterns in favor of the unique circumstances. We believe that equitable justice is going to be more beneficial on our side of the House, because its obligation is to really provide a particularized case-specific explanation that connects to the legal principle. So in essence, what we're saying is that human judgment would practice equitable justice betterly because there is more flexibility through human judgment and there is a wider parameter of understanding. However, on their side of the House, they've got the codified justice, the justice via algorithmic sentencing. Now, this refers to that routinized application of a very standardized procedure, right, to a set of facts. Codified justice would tend to eliminate both three things: explanation, restraint, or even the legitimation apart from the adherence to standardized procedure. In essence, what we're saying is what happens is when we're trying to compare equitable justice and the codified justice, we find that codified justice provides more harm. And the most inherent harm is the disillusionment. Now, disillusionment will alter the judiciary's internal composition, culture, and even its attitudes by eroding the confidence in the legal system's legitimacy. We find that the use of the codified justice in algorithms would prompt many to start looking at human judgments that were made in their past more skeptically, right? Which will cast doubts on other legal activities. Take, for example, people who start looking back at contentious social issues where judges may have passed sentencing that deprive one of life, liberty, or even property. And the majorly affected or the adverse parties would begin to question the judgments, and they would feel that they were the victims of human judgment errors, right? So by promoting or even advocating for this algorithmic justice, we're just going to cast a shadow of doubt for the human judgment and decisions that were made in the past. Secondly, panel, we bring forth the argument on necessity. Well, we claim that there is no urgency whatsoever for algorithmic sentencing to enter the judicial context. We believe that this argument serves as a response to first, the effectiveness of human judgment in terms of more accountability and effectiveness, and secondly, on the clash of how human judgment may get it wrong and the question on fairness brought about in the first and second speech, right? Now, the logical reasoning behind our reputation of the algorithmic sentencing as a replacement for human judgment is the fact that the appellate courts are going to always be a means to provide the transparency and accountability of a human judgment. Now, let us use the even if analysis, right? Even if we concede that human judgment fine is wrong, because obviously it's going to defending the status quo, right? It's wrong either due to the biasness, either due to the emotions brought about by proposition. We believe that we have a measure of recourse. Why are we saying this? That because the judicial system has the appellate structure. Appellate structure ensures that there is more accountability, because we believe that on our side of the house, it's basically impractical. Just a minute. It's basically impractical because even if you get a sentence that you're not satisfied at the magistrate level, you can always reappeal and through this appellate structure get more closure or even the accountability of the human judgment. We find that this is not the same case on government side. Why are we saying that? On government side of the house, there is no measure of recourse and even less accountability due to the algorithmic sentencing that is going to be used. Why are we saying this? This is because of the rigidity of these algorithms that decrease the ability to reverse decisions. Our analysis on this is a simple fact that is going to be using a similarly binary code as brought about in their model, where exact consistency, uniformity. So whatever binary code is going to be used at the magistrate level, that is the same thing that will apply on the whole spectrum. So what do we find from this? Our N7 is that we find that whatever sentence you're going to get at the magistrate level, even if you reappeal and get to the Supreme Court, there's a higher probability that you're going to end up having the same sentence, so therefore less accountability. In summary, we find that there's a lack of urgency for the replacement of human judgments, as we have brought to you the counter solutions where we think a more diverse bench is going to actually reduce this issue on biasness. And secondly, panel, we find that algorithmic sentencing in essence has no efficiency or accountability. Lastly, panel, our argument on alienation. Now, as an independent algorithmic sentencing plays a role in the legal system, we find that human participation will change and in some respects also decrease at a point. Our assertion here is that in the long run, the use of algorithms will start disconnecting people from the justice system. Now, in the case of algorithmic sentencing, it raises the prospect of alienation or even the tendency for some or all people to cease participating in the legal system and even lose interest in its operation. Why are we saying that? Because on government side of the house, extreme forms of alienation are imaginable, and on government side of the world, such as a fully autonomous legal system is also imaginable. A straightforward reason to worry about the alienation is that it would leave out the civic duty, it will leave out public education, and it will also leave out public accountability. That is why we ask panel to vote opposition. Thank you.
The speaker spoke for 8 minutes and 21 seconds.
Just give me a moment before you start.
We will now have a third speaker from the proposition to begin the debate.
Am I audible? If side opposition believes that judges are inherently qualified and will never be racist in all cases, we truly question why they even bother having a counter model to provide an extra level of accountability in the very first place. I think that is a concession that racism is ubiquitous within sentencing, and this is a problem that we need to structurally curb on both sides of the house. I have three key issues in this speech. Firstly, I would like clarity on what our model is, because there has been a numerous amount of misrepresentations the opposition pushes towards, and directly tying that back as to why those harms which they pushed on won't exist after I clarify it. And second, I'll look at opposition's model and why it's ineffective in curbing the harms they want to talk about. And finally, I'll talk about algorithms versus judges. Firstly, on clarity, opposition accuses us of not being clear on what the algorithm relies on to make a judgment. I think this is fundamentally a misrepresentation, because we give you a clear representation of what it was from the first place. We think on both sides of the house, there are existing legal metrics that judges use within the status quo. The unique difference here is that instead of letting a human judge with innate human biases allow particular metrics to override other metrics, we will allow a computer algorithm to objectively quantify it and weigh it accordingly. So, for example, when they said there are some cases where remorse is important and there are some cases where poverty can be a mitigating factor, we think as a human judge who is inherently racist and you're succumbing towards those inherent biases on status quo and on side opposition's house, you would neglect those kinds of systematic problems and you instead focus upon the fact that that individual is a minority, that that individual is a person of color, and because we've been normalized the idea that the vast majority of crime committed by these specific individuals, you tend to also believe these individuals are more prone towards crime and therefore are less aware of their problem, less able to correct themselves. We think a computer algorithm is uniquely unable to succumb to that bias. This is why we get the unique ability to solve it. They then push us as to why we'll get unintentional bias within our system because of data. Yes, on both sides of the house, there is data that currently states that majority of crimes tend to be committed by people of color, but what was unique in our mechanism was that we told you we are holistic in terms of the kinds of statistics we use and the kinds of data we use to compute our efficient and efficient kinds of sentencing. This means, yes, we agree the majority of crimes right now are committed by people of color and minorities in general. But what we go above and beyond for is to analyze why specifically. Therefore, we are able to objectively identify that this isn't a racial issue. This is the fact that these individuals were inherently disadvantaged because of economic stability, because they weren't given sufficient welfare. And that is an objective metric that our computer algorithms able to compute with objective data that is colorblind in nature. Because of that, we get proper sentences for these specific individuals. We think that's why we win that clash. But moreover, even if you think that some states are inherently biased, we offset that. Because on our side of the house, our computer algorithms can compute a vast array of efficient methods to solve the problem. So yes, we have crime rates right now, but what we also get is that we get to realization that Nordic models do tend to have a lower recidivism rate because they don't prioritize retributive punishment, which I would like to note was the fundamental principle that opposition highlighted in this debate. So we were very, very confused why they were even defending retribution and rehabilitation in the same line. Only on our side of the house, we compute that rehabilitation allows for lower recidivism rates, and our computer algorithm directly allows for this mechanism to appear. But second, they assert that our algorithm will be privately owned and hence will succumb towards harms like being cost effective. This was never our model. We weren't giving it off to a private corporation panel. We were giving it to an independent technocratic body based upon academicians that know the CJS in and out. They know all the systematic bias and flaws. The people that wrote the thesis about why the CJS system in America and throughout the world is uniquely pernicious and punitive towards people of color and towards minorities. The people that posted on like a lot of issues is the how the Brock Turner case, as to how Lamar Lloyd's cases were reflective of how the justice system sentences African American individuals and people of color far more perniciously. We think such individuals that are aware of these problems, and they will be the ones that fix it in the very first place. But they are uniquely more accountable in a comparative to judges, and here's how we win the first clash. Because on our side of the house, technocrats live and die by their academic integrity, insofar as they try to use racist statistics and do not fulfill their principal burden of solving recidivism and upholding the legal principle of impartiality before the law. They are going to be criticized with peer reviews. The comparative is, judges have a vast array of accountability mechanisms that don't actually work. The first reason is that they are able to easily justify their decisions by manipulating the legal metrics. The flexibility they talked about, the subjectiveness that they wanted, is the precise reason why a lot of judges get away with those specific problems within the status quo. They gave us no solvency to that specific issue. Final part of clarity is that I would like to note a lot of opposition's argumentations doesn't flow in this debate because they aren't contingent and unnuanced on sentencing trials, they are nuanced on conviction trials. So when I talk about the individuals who are like judges being able to understand the circumstances of those crimes, we think those are more uniquely pernicious towards conviction trials because you need to understand whether there was guilt in the first place that isn't applied. We're talking about crimes, and the vast majority of crimes, like crimes of necessity being committed by African American individuals and people of color, crimes like rape being committed by white people against African American individuals, we think in the vast majority of instances, the kinds of circumstances that apply in these cases don't really exist because it's a sentencing trial. Opposition doesn't understand emotion. Finally, they try to misrep us and tell us that our model is insufficient because of data collection. We told it is structurally untrue because data collection is separate in this case. Our data is one is holistic in nature. We don't get the problems they want to push on. Second part, I like to look at opposition's model and analyze why accountability on the outside of the house is crippled. The first thing they said, they wanted more judges from different backgrounds. I think the first issue here is that it's a concession that there are problematic sentences due to innate biases that they wanted to fix because they wanted people of different backgrounds to check and balance each other. So they inherently still have a risk of individuals from, for example, white backgrounds that would perniciously punish minorities and people of color. We think it's a problem they needed to deal with. But second, I would like to note this mechanism isn't as simple as saying you will have it. It literally doesn't apply to any legal metric system in the status quo. More specifically, you still don't change the structural barriers that blockade people of color and minorities from accessing the ability to become a judge in the first place, from the education in law school, from the kinds of career opportunities that isn't structurally barred from them with racism. All these structures they don't get to solve. They outside the house asserts a counter model that's infeasible in their nature. But second, they talk about judges seeking assistance from peers to pass a decision. I think it's a logical tension in their case when they argue each and every judge will be extremely qualified and perfectly able to use flexibility and subjectiveness to provide judge punishment. We think that's an issue. But second, this is also ineffective insofar as they're unable to curb the innate biases of judges within their side of the house. It is pointless to get peer-to-peer reviews of judges because the peer-to-peer reviews you get are ones in which is symmetrical, are ones that are still grounded with the kinds of racist tendencies and racial biases that exist. But at the final level, even if consultation is good, it's insufficient compared to our side of the house because the authoritativeness of good consultation isn't as clear or as maximized as an algorithm that's impartial in each and every circumstance. If they have some good judges, we have a good algorithm. In all cases, we win on the comparative. On the final clash then, on technocrats versus judges, they give a few reasons to why judges are inherently good. They say they can have a human view and the algorithm is unable to read emotions like empathy. I think they conveniently left out the vast majority of cases where these kinds of emotions and subjectiveness actually create tangible harms towards people of color and minorities in general. Your human view as a judge of a majority population, seeing the kinds of crimes being committed by people of color, inherently shapes your ability to view the world in an impartial way, which means the moment in which you see an African-American individual walk into your courtroom in the very first place, you assume that he's already guilty, you assume this individual already committed a crime that impacts your ability to give a fair sentence. We think that's unjust. On our side of the house, we think our computer algorithm is impartial and is equal when it comes to sentences individuals. You would treat all individuals on an impartial level and actually provide just sentences that fix recidivism by prioritizing rehab. Very proud to propose.
The speaker spoke for 8 minutes and 33 seconds.
Okay, can you hear me? Okay. So the side proposition came here today and they talked about, when our first speaker came from the side opposition, he talked about the social contract, right? And how the state cannot abdicate its responsibility to any other person other than itself, right? Then the side proposition came up and told us that when they are going to put in these algorithms, they are going to put an independent body in charge. And this goes against the social contract. Therefore, when the side proposition began to speak, they already began to nullify their case as a whole. I'm going to focus on three major points of contention in this debate. There was one on bias, accountability, and effectiveness. Now, looking at bias, the side proposition came here and told us that judges are going to be biased, right? Because if there's an expensive lawyer, or if a lawyer brings a case that they favor, then the judge is obviously going to be biased, right? Well, what we are focusing on here today is criminal sentencing. Therefore, by the time we've reached this point where you're being sentenced, it's because this person has already been proved guilty. Therefore, when they start bringing in lawyers and the judges being biased because of the case being provided, that is not a valid point in the debate we are having here today. They also talked about how judges are inherently biased and how judges have subconscious bias. Well, I'd like them to note that this is the same content that's being put into the algorithm. Therefore, if there's already bias within society, we don't understand how they are saying they are going to put in information into the algorithm, and this algorithm is automatically going to eradicate that bias. If this is bias that's already in the status quo, this is bias that's already in society, then this is bias that cannot be changed. Therefore, them saying they are going to bring algorithms to change that isn't possible. They also talked about how Black Americans they also gave us a situation where Black Americans are not providing required information to the state. Well, this takes me back to what I said. We are not talking about the whole process before sentencing. By the time we've reached sentencing, this is the same information that's going to be given to the algorithm. Therefore, whatever the judge has is whatever the algorithm would have if the algorithm was applied in this case, right? We've also talked about word embedders and how in society, when you're developing an algorithm, there are already word embedders, and this word embedders already put in the bias that's in society, right? For example, when a word embedder would put his to doctor or she to nurse, these are things that already exist in the society, and therefore when you're developing an algorithm, this is a required step. You're supposed to put in these word embedders. Therefore, the solutions we provided were much better to curb the bias that's already there in society, such as having more than one judge to look at a case, or having a judge discuss with their peers, or having a judge discuss with their peers on a certain case, because this would reduce the bias as compared to just putting in already what is in society, because this is a computer algorithm, therefore garbage in, garbage out. On the case of accountability, the side proposition came and talked about impunity and how if the judge will be considered above the law, right, the judge can't question for what it is they are doing. Well, I'd like to remind them of one more thing. There's something called automated bias, where people tend to prefer what algorithms say or what algorithms recommend over what they can see, over what a human might say, right? And this is already bias that is put in, yeah? And when you talk about accountability, we talked about having a judge, we talked about having a face. If there's any bias, and which we are not saying there's going to be bias, if there's any bias, then you can put a face to the judge that has looked at that specific case. You can put a face to the state, you can put a face to the judicial system, because that's where the bias was. But if we take in algorithms, then we are pushing for automated bias. It's going to be very difficult for you to question an algorithm. For example, look at the Facebook scandal. It's very difficult for the state to go and attack Facebook for whatever happened, because this is an algorithm. It's very difficult for human beings to go and say that what the algorithm said is wrong, because what they consider is that it's above all else, right? And we've talked about equitable justice and how we are supposed to look at cases on a case-by-case basis. But what the side proposition is pushing for is objective metrics, where they're going to have just one algorithm looking at all the cases, which is not applicable. This cannot happen because there's context, like we talked about. There are different things that can push to different crimes being committed. Yeah, that's why there are different sentences for different crimes, because there's a different context, there are different reasons for a crime being committed, and this cannot be noted by the computer algorithm. I can take your POI.
The only reason why you want human judgment is customized justice, which we told you that computers can deal with by calculating different metrics. So at the very best, all your benefits are symmetrical, and at your worst, you have to deal with all the harms that we told you about and you cannot run away from with reactive and uncertain mechanisms.
Therefore, what's your question?
Please engage.
Okay. You've talked about how, basically what we are saying is computer algorithms cannot put cases in context. You can't tell me, for example, the example that was given by one of our speakers, right? Someone had committed rape, and this was because this person was subjected to abuse. This was because certain things happened to this person. And this is the same information that the judge is receiving. Therefore, the judge can put this in context. And we don't understand how you're saying computer algorithms will be able to reason this out, how they will be able to put this into the context that it was in, because these are computer algorithms that were coded to work on a case. Therefore, they cannot work on it as a case-by-case basis, because different cases have different reasons as to why they occurred. Moving on to effectiveness, right? They talked about how we are not pushing for rehabilitation. Well, and they quickly assumed that having retribution means you can't have rehabilitation. Well, look at countries like Norway and Sweden that have rehabilitation-focused sentencing. This doesn't mean that the only thing they do when a criminal comes in is they push for retribution, or they push for harsh crimes, as the side proposition came and accused us of pushing up. We can have rehabilitation-focused sentencing. And when you're sentencing, we haven't said that we're just going to come here and talk about retribution, right? Then there's how rigid computer algorithms are. Let me give you an example. When we have algorithms for GPS, right, and how roads change and how traffic can come in, but the computer algorithm can't put this into context. The computer algorithm cannot consider this as it's giving someone maybe directions to a certain place 20 years after it was coded. This makes it very difficult for the computer algorithm to be altered or changed in specific cases where this might need to happen. Then they came and talked about flexibility, right? And how we are allowing for flexibility, but this should not happen. Well, flexibility is the bedrock of the judicial system. That's why we have different sentencing for robbers. Not all robbers will serve the same jail term. Not all robbers will receive the same sentencing, because we have three different sentencing, right? That's why we have appeals, because when they talked about bias and we talked about the different levels of recourse in the judicial system, then we have appeals. Therefore, if you feel like, for example, a certain judge didn't give you the right sentence, or a certain judge was being unjust, you can go through the process and actually receive the flexibility that we are talking about here today. Therefore, we are not against technology. We just believe that having technology in the judicial system is too sensitive and it just cannot happen. Thank you.
The speaker spoke for 8 minutes and 14 seconds.
May we now have the reply speaker from the opposition? Go ahead, please.
Right, can you guys hear me? All right, thank you. Panel, throughout this whole debate, right, our major question to proposition has been, why are we allowing algorithms into which no one in the criminal justice system has any insight to play a role in sending a man to prison, right? Their major answers, or rather the only answers that they could provide, are two. First, that it would reduce biasness, And secondly, that it would incentivize rehabilitation. And this has been the major clash points in our debate today. Now, on the first clash of how algorithmic sentencing is going to reduce biasness. They go on from first until the last page where they try and say that human judgment is easily swayed through bias, through emotions, and there's biasness in the status quo. Now, our responses to this have been plenty. First, we argued that there's going to be more biasness in the machines or even in the algorithms. How did we justify this? We talked about the data collection process, even if it is done by the technocrats whom they specifically said, and I wrote this down because the Fed speakers came to tell us that the technocrats know the system in and out, right? They have given examples of speeches that were written by these technocrats and these people that have this whole approach or have a whole insight into this criminal justice system. Point of contradiction comes in where panel they come to also tell us that this same criminal justice system is inherent to bias. And now we're going to use the same data that was written or given from technocrats, right? That is inherent to bias according to them, right? And we're going to use the same data and they call it holistic and they come and say that there's going to be less bias. Again, panel, another point where we talked about that there's going to be more biases or rather the harm from algorithmic sentencing are going to be much more harmful. It's on the point where they come and tell us that they're going to inherently reduce the biasness, right? And then they come and give us the point of rehabilitation incentive, which I'll come to, right? Now they come and tell us that they will solve the racism and the discrimination and all the biases. We have to understand that the sentencing is the last part, all right? It's the last part where we're going to just have the sentencing. But if they claim the police, right, during arrests are biased, they claim that the lawyers themselves are also biased. They also claim that maybe even the juries are inherent to bias. Ladies and gentlemen, their proposed model in turn does not solve any racism, does not solve the biasness that they keep on saying that they're going to try and solve, right? Because at the end, it just comes down to the judges. And these judges will just view the data that has been given by the alleged biased jury or even the alleged biased police. So in turn, what we're finding for proposition is that they claim that they're going to try and solve the biases, but in the end, we find that their whole model does not even substitute over the whole sort of clash was in the rehabilitation incentive. Panelists, it's very important to note that the justice system itself always tries to balance out rehabilitation and retribution. How do we say this? Let me give you an example of community service. Now, community service is like almost like a sentence, right? There is retribution, which in turn is like community sentence as a punishment, but it also plays along with rehabilitation. Ladies and gentlemen, we don't need algorithmic sentencing to come and incentivize rehabilitation. We already have human judges or even the criminal justice system and the guidelines of the law to accommodate us for that. That is why we feel that on their side of the house, it's really ineffective, it's unaccountable, and it's not even transparent as we brought out in our speeches. Right? Now, we find that the effectiveness and the accountability of human judgment as we had provided is going to be much more effective. We also brought on the issue of alienation, where we found there was no engagement. But last in final, we also showed how the machine bias is going to be more harmful. Now, we also talked about the appellate structure as a counter solutions where we found there was no engagement at all. And we also didn't see any responses or engagement on the social contract principle. That is why we beg the panel to vote opposition. Thank you.
The speaker spoke for 4 minutes and 18 seconds.
We will now have the reply speaker from the proposition to close their case and close the debate.
Hi, am I audible? Panel, the strategic flaws of opposition are twofold. Firstly, that most of their harms flowed from a misunderstanding of our model and not wanting to engage with the critical nuances Ejen told you with regards to how this algorithm would function. But secondly, that most of their argumentation was mitigatory in nature. That is to say that we have appeals, that is to say we have checks and balances that did not want to recognize the severity of racism in the status quo. We think it's abhorrent that they would choose to ignore the stories of human suffering because they chose not to engage with our model. I'll make it very clear in this debate and talk about two things. Firstly, on the model. Secondly, on justice, racism, and bias. Firstly, on our model, we told you right from first very clearly that the mandate to construct an algorithm would be created by an independent body that is not beholden to any sort of political interference whatsoever. That it would be consisting of criminal justice technocrats who are tasked with an objective metric of wanting to reduce recidivism. The reason why this is important is because it is categorically different from judges who are subject to their inherent biases and their inherent metrics and personalized interpretations of the law. Because now, when we have an objective metric that says you need to get the rates of recidivism down by 10%, that means objectively that they have to use rehabilitation as the model to overcome that, because it is the proven model to ensuring that recidivism goes down. That is what is effective. We said, moreover, that this would be one in which could be continually improved and we could have the sorts of reforms. I do not why it is so hard to change an algorithm. We constantly do it already in the status quo. What did they say? Firstly, that we would use more judges. We told you that this was abhorrent because you rely on the luck of the pool. But here's the thing, even if we take them on the very best case scenario and they root out racism, they still do not take into consideration all the multitude of subjective interpretations of the law we told you about. So they still have to deal with undermining equality before the law, because some judges choose to overpunish, some choose to underpunish, and all the harms we told you about aggravating factors. They just had a simple response. Look, guys, the statistics is still racist. If that's the case, I think the harm is symmetrical, but we told you it's not, because our algorithm is specifically tailored to curb for this racism. They said that, look, the use of technology leads to disillusionment. We told you since second that trust for algorithms is far greater than humans. In the same way that the state has failed them, now they would think human judges who are fallible will fail them. It's far harder to challenge an algorithm that has been objectively programmed to lower recidivist rates. That's why the outrage and this lack of trust only happens in their world with instances such as the uproar caused by Brock Turner, the uproar caused by George Zimmerman. They told us, look guys, we have checks and balances such as appeals. We already told you appeals are insufficient, they're expensive, and the poor and minorities often cannot access these structures. We say that's bad. We furthermore told you why rehabilitation is exclusive to proposition because human judges in the status quo are overly punitive because of society's view on criminals. That's why we have a 60% recidivism rate in the United States. But secondly, on justice, racism, and inherent biases, the main claim coming from them is that customized justice can only be delivered by human judges. This did not at all engage with what firstly we told you, that we don't have a finite set of metrics for the computer to compute. So the computer can compute those differences. So even though two black men committed the same crime, we told you their financial record would be a mitigating factor and we can still take this into consideration. We told you we can still have clinical psychologists compute this information in and thereby have an equal weighing of all these metrics, where on their side of the house, a racist judge might use racism and the race as the sole metric to determining their sentence. We told you about why the vast subjectivity of decisions human judges guarantee that circumstantial justice isn't accurately administered. Because what is just in the eyes of the judge may not be what's just in the eyes of the victim. We told you systematically that human fallibility was one that currently poisoned the justice system. For all those reasons, we think it's principally abhorrent of opposition to recognize that racism exists but not do anything to curb its flaws and its damages in the status quo we're so proud to propose.
I'd like to thank all the speakers for a fine and engaging debate. Congratulations to both teams for an excellent performance. We'll be moving shortly into the deliberation breakout rooms, and then you all can wait over here while you come back. Best of luck to all both teams.
Thank you.